Now we're going to formally begin our programming today, and it is my great pleasure to introduce my longtime friend, Krista Chaytor from WeirFoulds. As an experienced litigator, Krista's practice includes business disputes related to commercial leasing, construction, real estate, shareholder rights, and employment. She handles complex business litigation and has appeared before all levels of Ontario courts. She also has experience in alternative dispute resolution and effectively provides advice and opinions that result in practical business solutions for her clients. Krista, thanks for joining us today. Thanks for introducing our keynote speaker, and thank you for facilitating our keynote fireside chat. And with that, I will turn this over to Krista.
Hi, everybody, and welcome to Toronto. We have been waiting so long for you to be here, and it's a real pleasure. Everyone at WeirFoulds is so happy you're here. Some of you have heard us talk about how much we love this city, and now you get to decide for yourself whether we're right. So welcome, everybody. Today, it is my sincere pleasure to introduce to you the Honourable Binnie, retired Justice of the Supreme Court of Canada. As a litigator and quite frankly, just as a citizen of Canada, this is a real honor for me. Justice Binnie is truly one of the most respected legal minds in this country. He was recognized as an advocate before he ever went to the bench, and in fact, he was appointed to the Supreme Court of Canada from being a practicing lawyer. And he'd been at the Supreme Court of Canada as an advocate many, many times before he ever got there as a judge. He then served our country on that court for almost 14 years. And during that time, he authored more than 170 opinions. I'm just gonna let it sink in, 170. I think the only thing I've sent that many of or written that many of is texts. And it's not just the sheer number of opinions that's mesmerizing, it's the quality of those opinions and how much they've meant to this country. That's even more mesmerizing in my view. Justice Binnie has written leading opinions on all kinds of topics, all kinds of legal issues. Diverse points of law, from intellectual property to our Constitution to regular commercial disputes. When Justice Binnie retired from the bench in 2011, a newspaper here in Canada wrote that Justice Binnie is perhaps the most influential judge in Canada in the last decade. And yet somehow when I read that, I thought, it seems like an understatement. Since leaving the bench, Justice Binnie has continued to take on public service roles. His dedication to Canada has been recognized with the very prestigious award of Companion of the Order of Canada, which is awarded for merit to Canada and also humanity. Justice Binnie is also recognized all over the world, not just here in Canada. Justice Binnie is currently practicing of counsel to a very respected and fortunate litigation firm here in Toronto, and he's also a very respected and sought-after arbitrator. Thank you, Justice Binnie, for joining us today.
Well, thank you very much, Krista, for a rather overly generous introduction. But I don't have time to mount a rebuttal. I'll leave it as is. The topic I've been asked to speak on would have been unbelievable when I got called to the bar 57 years ago. Judges really had very little to say about social and political issues. They were, generally speaking, very conservative individuals who stuck closely to the letter of the law. That era was not a golden age, but it was a different world. Lawyers and lobbyists didn't expect to become as rich as their clients. The preoccupations were fairly simple. I noticed from your list that there are a number of lawyers from Ireland here, and my favorite snapshot of the laws that used to be practiced is a book called The Old Munster Circuit, in which it talks about the barristers as they trekked from village to village, county town to county town. And I do recall one where a lawyer was arguing a case in a country courthouse, and there was the inevitable Irish donkey in a field next door, which began to bray. And the judge said, "One at a time, please, Mr. Flaherty, one at a time." And Mr. Flaherty said, "I'm sorry, my lad, I couldn't hear you for the echo." In these cases, lawyers always up the judges in repartee. But you fast forward to today, when this notion that judges should wade in on social and political issues of high controversy is begrudgingly accepted. When I was appointed to the Supreme Court, I received from an American friend a reference to Justice Frankfurter, who in a letter to one of his colleagues said, well, there are some good things about an activist court, but he said it isn't worth the price of having 5 men, i.e. a majority of the court, quote, without any reasonable probability that they are qualified for the task, unquote, determine the course of social policy for the states and the nation. Now, since this topic was assigned, of course, there's been explosive development in the United States in the case of Dodds and Jackson's Women Health, and the overturning of Roe versus Wade, and I don't plan to plunge into that maelstrom, except to say that both sides in that debate purport to be non-political and not interested in the policy behind the reasoning. The majority say, well, we're simply correcting an overly activist position taken in 1973 by in Roe versus Wade. And the dissenters say, this is an overly activist, conservative, quote, supermajority, unquote, taking away rights which have been enjoyed for decades. In Canada, I point out that we had this particular issue in the early 1980s when the Supreme Court struck down the prohibition in the criminal code against abortion, except under, there was an administered procedure whereby abortions could be obtained. But the procedures had to be complied with, and the court held that the procedures unduly hindered access to what was intended to be a right of a woman to, in consultation with her doctor, to have an abortion. When I was on the court, there were a number of highly political decisions really put upon us. We didn't ask for them, but they come winding up through the court system, and they have to be dealt with. Unlike the executive and legislative branches, the courts have to deal with what's put on the table in front of them. And I'll come back to those in a few minutes. I just want to emphasize that this is not peculiar to the United States or Canada. There was huge controversy in Britain over the Brexit debate when the Supreme Court said that it was unconstitutional for the Prime Minister to have recommended to the Queen the dissolution or the prorogation or suspension of Parliament. And all of those decisions in Brexit were lambasted from both sides of the spectrum. At one point, a headline in a major newspaper in Britain had 3 judges who'd made a decision the paper didn't like, and the big headline was "Enemies of the People." So, well, whether judges like it or not, they are being plunged into these social and political issues. And one of the problems, both for the public and for the judges, is the perception that the appointments process is too much of a control over the outcomes. And this is brought to light not only in something like Roe versus Wade, where you have this reversal of position, but in Canada we had the reversal of a decision in the 1980s that said that if the United States requested extradition of a fugitive, knowing that the fugitive faced the death penalty in the United States, and Canada does not have the death penalty, could the government constitutionally surrender the fugitive back to the United States? The earlier court said, well, yes, the crime was committed in the United States. The person accused of the crime must be understood to have to be governed by the law where the offense allegedly occurred. 25 years later, the Supreme Court said, no, we don't have the death penalty. The executive, the cabinet, the government has no right to surrender somebody without assurances that the death penalty will neither be asked for nor inflicted. More recently, there was a reversal on the issue of physician-assisted suicide. Highly political, highly social issue. Can somebody with a terminal illness in great pain seek the assistance of a physician without traveling to Switzerland for life to be terminated? In the earlier decision in the 1990s, the Supreme Court said it's up to Parliament. The Criminal Code of Canada outlaws, prohibits the assistance of suicide, and it is for Parliament to change it if Parliament sees fit to do so. Within the last couple of years, the Supreme Court, differently constituted, went the other way, saying that there is in the Constitution a right to life, liberty, and security of the person, and the Criminal Code provision impermissibly encroaches on that right. Now, some would say, well, that's just a reflection of the changing composition of the court, both in the United States and in Canada, and I'm sure equivalent decisions in Spain and other countries represented here. So the problem from the court's point of view is legitimacy. How does the court establish that the decisions that it makes are not the product of personal opinions parading as law, but actual decisions according to law? In the United States, one of the answers is originalism. The judges are constrained by what was understood by the people who ratified the Bill of Rights and the Constitution. Well, that's fine, although it's controversial even in the United States. Thomas Jefferson said you might as well ask a man to wear a coat that fit him as a child. You know, people grow, needs change, the Constitution has to change with it, and that is the view generally taken in Canada. You know, but more to the point is originalism, any more than the so-called living Constitution perspective, is in the eye of the beholder. You know, it is said we live under the law, we live under the Constitution, but it is the judges who say what the law is. And therein lies the problem of legitimacy. The appointments process is an important factor. And if you have a partisan appointments process or elections, you're going to have partisan judges. My own view is at the end of the day, it comes down to essentially a sense of professionalism and self-discipline on the part of judges to watch and be very careful that what they're deciding has some powerful legal basis to it, and it's not simply prejudice or preference. Now, this was brought home to me in my first week on the Supreme Court of Canada, fresh from practice, when the court was faced with a reference from the government as to whether the province of Quebec, if the population voted in favor of leaving Canada, would be within its constitutional or international law rights to do so. So this, I mean, you have to realize is an absolutely existential question. Here, Quebec has about 40% of the population, I guess more or less equivalent to California and New York, put together, and it's right in the middle of the country. So instead of losing the coasts, which some Americans, I guess, would like to see happen, in this country, it would leave a giant hole right in the middle. But just as abortion and some of these hot-button issues carry the day in the United States, in Canada, it is language and culture. You cannot be appointed to the Supreme Court of Canada unless at the time you're appointed, you are functionally bilingual in both French and English. The very large French community in Quebec is matched by French minorities across Canada. So in Quebec, it's a majority right. Across the country, it's minority rights. The secession movement, the separatist movement in Quebec, has not always been peaceful. During the early days, there was a good deal of violence in Montreal with bombs being let off in the federal police headquarters and the Montreal Stock Exchange. There were riots. One of the elections was marred when the sitting prime minister was confronted with bottle-throwing protesters. So, from the French-speaking point of view, this is cultural survival. They live in a sea of 400 million people who are essentially English-speaking. Unless somehow they can protect that distinct identity, that French identity is going to disappear. So when there was a referendum that only lost by less than 1% of the vote, think of it, there was some 97% of people eligible to vote in the referendum voted. At the end of the day, it was 49.0000 something versus 50.000, less than 50,000 votes out of a total of 40 million. Had it gone the other way, Quebec would have been gone. So the government said, well, we have to get some ground rules here. It's not a question for the courts as to whether or not Quebec leaves, but it is a legal question as what is the framework within which that decision can constitutionally be taken. So the government, we have advisory opinions here. I know they don't have them in the United States, although I think in the early days they did. I think John Marshall made a number of advisory opinions to the early presidents, but it is not now considered to be a case of controversy or whatever the phrase is. But here, the government can ask the court for a question, a question on an opinion of constitutional or public law. And the court is not bound to answer. The court can say, this is not a legitimate question for us. This is purely political, take it elsewhere. But if there's a legal component, the court is obliged to do what it can to resolve the controversy. And so it is with this case that came on my desk in my first week as a judge. Would Quebec, if it voted in favor of leaving Canada, 50% plus one, be able constitutionally and unilaterally to leave Canada? If not, as a matter of international law and the principle of self-determination, could Quebec leave regardless of what the Canadian Constitution says if it were recognized in the community of nations internationally as a separate state? And if the answer to those questions was inconsistent, which prevailed. Now, there's, of course, a huge background to this in the US with the Civil War. First of all, Lincoln made it perfectly clear. He said, no state can in any way lawfully get out of the Union without the consent of others. It is the duty of the President and other government functionaries to run the machine as it is. So the door is slammed, and the Civil War ensued. As to whether the courts would have anything to say, Lincoln said, if the policy of the government upon that vital question affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties, the people of the United States will have ceased to be their own rulers. Well, you know, that was all very well in 1861. In 1995, the Quebec referendum was held. There was no Army of the Potomac. There was no alternative to resolving this impasse other than to try to at least get some agreement on whether, for example, 50 plus 1 was sufficient to break up the country. So the issue came before the court. It emerged that Quebec, in fact, had lined up a good deal of international support, particularly France. Had the referendum gone the other way, the evidence emerged that France had would forthwith declare that it recognized Quebec as a separate country. And one can imagine the chaos, the legal vacuum that would follow by the sudden departure of a large chunk of the country. The court was faced really with two quite unpalatable alternatives. The federal government was saying, Quebec can't leave without a formal constitutional amendment. Well, in any country, a constitutional amendment is extremely difficult to come by. So in effect, the federal government was taking the Lincoln position, you can't leave. Canada does not have a provision, as do many countries, including France, that it is one and indivisible. But the federal government said that is the effect of the constitutional amending formula. Quebec wasn't actually the Quebec government, they refused to participate, but amicus curiae said, well, no, this is not for Canada to decide. We're trying to break away from you. It is not for you to try to tie us down with a constitution whose terms we reject. And the answer to that, of course, is that the principle of self-determination depends on establishing that the minority is oppressed. You know, it is urged by the Kurds in Syria and minorities elsewhere in North Africa and elsewhere in the globe, the indigenous people in Japan, saying we have no role in this dominant society. Well, and so happened at the time of the Quebec referendum, French-speaking Canadians were occupied the position of Prime Minister, Governor General, Chief Justice of Canada, and the Quebec members were absolutely critical in the support of the federal government. So when I say that the courts are sometimes not only the appropriate, but the only potential way out of hugely controversial social and political issues, how did the Supreme Court resolve the Quebec secession issue that in the United States led to war, and in many South American countries, a separation led to war, and some kind of peaceful resolution through the courts? Well, the court said, look, there is nothing spelled out in the Constitution, but there are certain principles that are helpful, that create a framework. The principle of democracy means you cannot lock in Quebec forever. It is no answer to a majority in Quebec who want to leave to say you can't. You know, that is a continuing turmoil, this so-called house divided against itself. The court said democracy is key, but also the rule of law. Unilateral secession would leave a legal vacuum. What happens to the currency? What happens to the agreements, commercial agreements, interprovincial, federal provincial agreements, defense? All of these things would be vitiated by virtue of Quebec now being recognized as a separate sovereign state. The court said the fourth unwritten principle is federalism. Unilateralism has no place in federalism. The converse of federalism is multilateralism, that we're in this together, and if there's such a giant problem in the family, it's got to be sorted out together. Therefore, there is an obligation. If Quebec votes to leave, there's an obligation on the rest of Canada to sit down and try to work through the differences. And if the differences are insoluble, then Quebec has the right to depart. And then there were other provisions dealing with minorities and principles. Now, the whole notion of unwritten principles is dangerous territory. It is really what the court in Dobbs was complaining about Roe versus Wade, the penumbra and privacy rights and so on, that are not written in the Constitution, but which were derived from a sort of general understanding of constitutional principle. Many of the academics in Canada were very upset at the court's decision. But in fact, the federal government accepted it. They said, look, this is a framework that we can work with. At the end of the day, the decision is political, but it is useful to have this framework that everybody knows where they stand and what has to be done to accomplish whatever it is they want to accomplish. The Quebec government, which was a secessionist government, which had been pushing for separation, said, well, we accept the framework as well because it imposes on the rest of Canada the obligation to negotiate, and if the negotiations are successful or not successful, we have the option to leave lawfully. And a lawful departure will command a much higher level of international recognition of sovereignty than an exit which is thought to be unlawful. I mean, don't remember, there are all sorts of countries around the world looking at what happens here. The Basques in Spain, Scotland in the UK, many different countries have this issue of a region that is unhappy with this. Catalonia, of course, a major example. So the solution to my way of thinking was a sensible solution. When Frankfurter says, well, what gave these people, what qualified these people to make this kind of decision? My answer is there's nobody else. In a written constitution, you've got to have an umpire. You've got to have judges who are making these decisions. And the test ultimately is one of legitimacy. Do the people feel, and of course this is now going on in the United States, this debate, do people feel that even though they disagree with decisions, that those decisions are made by a legitimate process according to a legitimate reading of the law, in accordance with legitimate legal traditions, and not by reason of personal or political preference. Thanks very much.
Thank you very much. We now have a few minutes if anyone has any questions. Let us know. There is a mic circulating in the room. If anyone has any questions, we can ask. Just put up your hand and we'll bring the mic to you. In the meantime, while we're waiting for questions from out there, I have a question for you. When you were on the bench, how did judges maintain collegiality in the context of so many different opinions and sometimes, I'm sure, strong opinions?
Well, it's difficult. You're essentially with the same other 8 people, week in, week out, year after year. You have to make a very conscious decision that you will not allow rifts to develop, personal rifts. We had a situation in British Columbia a few years ago where two judges weren't speaking to one another. And it so happened on one occasion, one was going down in the elevator and the other got in. And the one who was in the elevator said, "I would like it to be clear that it is I who is not speaking to you." So there's you have to avoid cabals. In the United States, we don't have this problem. There is a recognized bloc, recognized by themselves as a bloc, conservative and liberal. Here we do our very best to avoid that kind of pigeonholing, and in fact, it's very difficult to discern in Supreme Court of Canada decisions who appointed which judge, which party, the Conservatives or the Liberals. I once heard a lecture from a member of the Tokyo String Quartet, which played together for about 40 years. And he was asked the same question you're asking me. He says, the answer is we have as little to do with each other as possible. We don't stay in the same hotel. We don't go on the same aircraft. We meet to make music, and that's it. In the Supreme Court, we make a point, or we did when I was there, of not discussing the case amongst ourselves until the hearing. So you didn't have blocks forming in advance of the hearing. So precautions are taken, efforts are made. Every judge commits themselves to keeping the peace and to keeping relations cordial, regardless of very serious disagreements.
Thank you. Admittedly, I can't see very well. I think over here there's a question. Thank you.
Can you hear me? Okay, there we go. Your Honor, was the Quebec decision, was that the product of a request for an advisory opinion? Or did it come in the context of contested litigation?
It was initiated as an advisory opinion. So what happened was that the Quebec government referred the question to the Quebec Court of Appeal. Different governments, provincial governments sent these references to different courts of appeal. They all came together in the Supreme Court. There was no private litigation. There was no litigation between governments. It was all in the form of questions posed for an advisory opinion.
I'm trying to understand your process from the United States, and in my jurisdiction, Louisiana, we do not have that. In fact, our courts are go out of their way to avoid jurisdiction over any sorts of hot potatoes, as we would refer those sorts of questions. So as I understood, the question got into the judicial process from the civil government that went to the judiciary, which moved it up the chain, and then you all got it, I guess, under discretionary jurisdiction, your discretion to exercise jurisdiction over that question. You could have, as you heard you say, you could deny it and just say that we don't need to be involved in it. Yes.
The appeal is as of right to the Supreme Court of Canada, but the Supreme Court has a discretion to say, we don't think it's appropriate to give an opinion at this time.
So you will decide not to decide if that's what the tribunal decides to decide.
I might say it's a totally inappropriate question because there's no front-end vetting of these questions. There could be a very strange question coming out of some provincial government, and the court could say, you know, it doesn't make sense for us to give an opinion on this.
Thank you very much.
Your Honor wrote a dissent in a trilogy of cases regarding the extent to which the police could interrogate accused persons. This would be the Sinclair-Oikle squeeze, as you put it. Over 10 years since Sinclair was decided, how do you feel that this trilogy of cases has affected policing in Canada and the rights of an accused person?
Sorry, I didn't catch the decision that...
this would be the trilogy of cases of Sinclair, Singh, and Oikle.
The interrogation trilogy.
That's right.
Yeah. And you say they've all been overruled? No,
based on your strong dissent, they maybe should have, but...
no, the Supreme Court has the three issues that you're referring to, the trilogy, right to counsel, right to silence, and I don't actually remember the third you recall, but they all had to do with police powers in dealing with people detained, people taken into custody, not people on the street, people in the police station. And those cases, you know, the right to counsel, Americans will be familiar with the Miranda rule. We don't have the Miranda rule. Whether or not you're entitled to have counsel present depends on the circumstances. You're entitled to consult counsel. Usually this means that you telephone from the police station, you talk to a lawyer, the lawyer knows nothing about the case, so the lawyer says, don't say anything. Then as the interrogation proceeds, there may actually be questions. You know, I want to know, counsel, the police say this, is that right? The Supreme Court in this trilogy being referred to said, well, no, if it's the same charge and there's no increased risk, you've had your consultation with the lawyer, and that satisfies the constitutional obligation. And I dissented on that, and recently the court has kind of walked back that hard line, so there's much more discretion involved. The right of detention is another matter, and you know, again, is a contrast to the United States, and I think also to Britain, although the British rule is a little more difficult to discern because it's the common law powers of the British police. But it involves somebody who's, you know, probably rightly suspected of doing something, who's standing outside a store with a crowd of people, there's been a robbery, and the police come up to him and say, I want to talk to you, stay there. And then they come back, the guy stays there, come back and asks him questions. He says, I was detained. I was, you know, when a police officer tells me to stay there, I stay there. And the court in that case, again, I dissented, they you know, said, well, no, as a matter of law, you were free to go. Well, I don't know how many of us, you know, would walk away from a policeman and say, well, you know, tough, you don't have any basis to tell me to stay here. So there are these, you know, ebbs and flow. I think what to me is significant in terms of today's topic on making these effectively social and legal decisions. How are the police to interact with people? What are the rights of somebody detained? To what extent can you stop and frisk? These situations in the states where you stop a car because of traffic infraction, and then you look for drugs in the car, or you ask about drugs. We had a very bad case in Alberta, where an Indigenous man was stopped because he didn't have a license sticker, up-to-date license sticker on his license plate, and was forcibly arrested. Quite unnecessary violence. So many of these are important social issues. They shouldn't be left up to the judges to decide. Sniffer dogs is another example. All the time you have drug cases where sniffer dog evidence is key to say, well, I arrested the guy because the sniffer dog alerted. That gave me reasonable grounds to search the suitcase. I opened the suitcase and I found drugs. Well, of course, the only time these cases get to court is where the dog has been right. Doesn't count the thousands of times the dog was wrong. And so in a place like Australia, the dog handler, the policeman, has to keep a log. Is this dog any good? And also dogs are quite specialized. It seems, some dogs are very good at drugs, other dogs at dead bodies, other dogs do this, that, and the next thing. So there's a whole, culture surrounding sniffer dogs that Australia has addressed in legislation, and we don't. So that's another social issue. To what extent, if you're standing in an airport, well, the airport's a little different because it's an immigration matter. But if you're standing at a bus stop in downtown Toronto, can the police come up with a dog and start sniffing? That's a civil rights question. So all I'm saying is that these issues, I think, are extremely important to have public input. It's extremely important to have public education. But the fact is that the legislatures here in Parliament are not acting. When I was on the court, time and time again would say, look, this, including sniffer dogs, this is an issue that requires Parliament to look into it, have an inquiry, collect evidence, look at the options, and do something. And time again, Parliament has been preoccupied with other things they regard as more significant. So it's left up to the judges whether they like it or not. So, that is an aspect of this topic we're talking about, which has to be kept in mind. A very well-known and highly regarded judge on the Supreme Court, when our charter came into effect in 1982, said, this isn't part of my job description. I didn't sign up for policy and political questions, and threatened to resign. Fortunately, he didn't. This is Jean Betts. It was probably one of the greatest of our constitutional law judges. So the judges themselves have as many unhappy members at this agenda as some members of the public.
Well, thank you very much. I have an entire page of questions, which we won't get to. I know that you've been very generous with your time. And on behalf of everyone at SCG, I'd just like to say thank you very much for coming to see us today. We really appreciate it. Thank you very much. And we just have a small token of our appreciation. It would never be enough. It's been my honest and sincere pleasure.
Thanks very much. Bye-bye.